the privacy practice lead for Secure State. And today we will be conducting a presentation on preparing for the GDPR. Before we get started, I wanted to just briefly introduce myself and Secure State. Secure State is a management consulting firm specializing in the management of information security. We've been in business for approximately 17 years, and we specialize in helping organizations navigate the world of information security. And my role here at Secure State is to assist clients who have privacy concerns navigate the relevant regulatory environment. For myself, I've been a practitioner now for more than 20 years. I've got experience mainly in the healthcare industry, but I've held a variety of positions in healthcare and in industry, mostly on the compliance and audit side. So I've got a lot of experience working with frameworks. I have worked internationally with organizations, helping them to navigate compliance frameworks. So here's the agenda for today. I wanted to start off with a discussion of some key terms because there's some new concepts with the introduction of GDPR, and I'll be referring to these key terms throughout the presentation. Next, I wanted to get into a brief history of the GDPR and how we got to this point in time and what's in store for us here in the near future. That was going to take us into a discussion next of the significant impacts that organizations and individuals can expect from GDPR. And then that will lead us into a discussion of how GDPR applies to you or your organization. I also wanted to spend some time talking about data subject rights. And then that will lead us to the significant to-dos for data controllers and what their requirements are. Some key concepts that I want to talk about from a data controller perspective are the position of a data protection officer and what those requirements are. And then we're going to wrap up the discussion with a summary of the top 9 things that every organization who's concerned about GDPR should be addressing in the near future, if not already. Once we've concluded with that, I'll briefly wrap up with some discussion of what we here at Secure State can do for you, as well as take suggestions and questions at the end of the webinar. I should note we have a significant number of people today on the webinar, and we have elected to capture all of the questions answered and unanswered in today's webinar, and we will be posting all of those answers in a follow-up blog to this webinar. So you will, if you're on the webinar today, you'll receive an invitation to that blog, which we'll be publishing here in the near future. So as I mentioned, there's a couple of key terms that are relatively new. The first would be a data subject. And a data subject is simply an individual who resides in the EU whose personal data is processed by a controller or a processor. A controller is simply the person or entity. A data controller does not have to be a commercial enterprise. It can be an individual. But the data controller is the entity that has the relationship with the data subject. And the controller is who determines what data is going to be collected, how it's going to be used, and ultimately how it's going to be disposed of. A data processor is another entity or individual. Typically, it's a subcontractor of the data controller, or it could be a business partner that's involved in the processing of data on behalf of the data controller. A data protection authority is a national entity that is created by a member state within the EU that's tasked with the protection of data and privacy, as well as monitoring and enforcement. Data protection authorities have been in existence now for more than 20 years in the EU. For those of you in the US who are on the webinar today, the equivalent here in the US would be the Federal Trade Commission. Main establishment, this is the location in the European Union where decisions are made about data processing with regard to what is being processed. So for organizations or individuals that are headquartered in the EU, this would be your main establishment, and I'm referring to the member state in which you're located. For those entities that are outside the EU, this could potentially be the member state where you do business, or the member state where you do the most business, or where you've chosen to make your main establishment. A supervisory authority is another public authority. It's specifically called for in the GDPR. So what makes it different from data protection authority is a concept that's been in existence prior to GDPR. Within GDPR, it specifically calls for a supervisory authority within each member state, which will essentially be responsible for managing any data controllers within that member state. They'll provide guidance to entities within the member state and provide additional terms for cross-border processing, which is a generic term that's used to describe when data on a particular individual is taken from that individual's state across an international border. So the next slide, what we're attempting to do here is just show sort of the progression over the last 35 plus years in the world of EU data protection and privacy. And in my research, I found that, the first data protection law was back in Germany in 1970. And there was a follow-up law that was passed in 1983, which was essentially the first instance where the data on a particular individual, in other words, personal data or personally identifiable data, would be accrued to an individual, meaning as an individual, they own the data about themselves. Now, it took a number of years before we sort of reached the next stage in the evolution of data protection and privacy in the EU, and that was the EU Directive on Data Protection in 1995. This is when you started to see some of the first data protection authorities established by law within the EU. And for a long time, this governed, how data was being protected and privacy rights were maintained in the EU. In 2000, Safe Harbor was established, which was essentially a mechanism by which the United States and the EU developed a framework where companies based outside of the EU, most notably in the US, could obtain a measure of mitigation by agreeing to comport against 7 key principles in the area of data protection. It was a self-certifying mechanism, and that was essentially the law of the land and governed companies doing business in the EU all the way up until 2015. Between 2000 and 2015, there were a number of notable breaches around the world. And in the 2000s, you started seeing individual nation states passing stricter data protection laws. And in 2015, the European Court of Justice invalidated the safe harbor, essentially calling it unconstitutional and requiring the EU to develop a new regulation to govern data protection and privacy. In 2016, the GDPR was adopted by the European Parliament, and it's scheduled to be implemented in May of 2018. So, you know, the chart here is just a representation of complexity of regulation and resources required matched against time. So from my perspective and in my experience, there's some sort of unique concepts which have been bubbling around over the past 20 to 30 years, and they've now come to fruition into GDPR. And we're going to start getting into those here in a moment. So let's talk about some of the significant impacts of GDPR. There's a number of them, but we have limited time today, so I just picked out a few that I think represent probably the greatest areas of risk for organizations. And these are a combination of financial impact as well as operational impact mixed with the regulatory aspects of this. And the first is this concept of extraterritorial applicability. What GDPR does is it applies to all entities regardless of where the entity is located if the data in question is pertaining to a resident of the EU. This is something that's somewhat novel, and it's going to present an interesting challenge for organizations to fully understand, you know, what their data infrastructure looks like and how to comply with each of the individual terms of GDPR. Next up is the penalties under GDPR, which max out at 4% of annual global turnover or revenue, if you will, or 20 million euros, whichever is greater. This represents a significant ramp up in financial penalties. In examining some of the breaches that have occurred in the past several years, a breach that occurred a few years ago that would have resulted in a fine of several €100,000 could now represent several million euros in fines for organizations. And then finally, there's a dramatic increase in how consent must be obtained and given under GDPR. Essentially, consent now for an organization to harvest someone's personal data, that consent has to be easily recognizable. It has to be able to be differentiated from the rest of the process by which data was obtained. And finally, that consent must be as easy to withdraw as it was to give it. One of the other concepts that I wanted to just spend a moment on in terms of its impact is talking about cross-border data transfers, because in a global economy, this is one of the key elements that I think for most organizations is going to present the greatest challenge in terms of understanding data and being able to comply. So there are a number of entities within the EU that can impact GDPR. You have the European Parliament, which made the regulation. You've got the EU Commission, which is charged with the administration of regulations within the EU. And then finally, you've got the Council, which is essentially a strategic body that's made up of the heads of state from the 28 member states of the European Union. So what I've depicted here on the slide is the paths, if you will, that an organization could get to allow a cross-border data transfer. First, the Commission would have to decide that an entity outside of the EU, be it a country, a territory, an international organization, has ensured an adequate level of protection. So this implies some form of a treaty or agreement. Absent that, the data controller would have to go to the Commission in order to obtain a list, essentially, of safeguards and conditions under which you could do a cross-border data transfer. And included within that would probably be some binding corporate rules approved by the supervisory authority. In other words, this would be a set of formal guidelines and principles that a company or an individual has crafted, submitted to the supervisory authority, and gotten their approval so that there would be no question as to how the controller would handle the data subject's data and their attendant rights. And then, of course, you could have a judgment of a court or some administrative authority of a third country, based upon an international agreement that would allow a cross-border data transfer. As it pertains to the data subject, there's a couple of paths for a data controller to execute a cross-border data transfer. Of course, the data subject explicitly consenting to the transfer would be one. Having a contract in place, or the execution of a contract where the data subject was referred to in the agreement. Having an established reason of public interest, think national security or public health. Other legal claims or protecting the vital interests of the data subject or other persons where they were not able to give consent. Those are the ones that I've typically seen listed in the literature as being able to allow a cross-border data transfer. Those are essentially the significant impacts. There's obviously more, but that's really all the time we have for today to talk about those. Next, I wanted to go through an exercise that an organization could do in order to determine if GDPR is applicable. So in my research, I've identified 4 central questions that an organization could ask itself in order to determine if GDPR is applicable. The first is your entity located in the EU? So obviously, if you're in the EU, GDPR is going to apply to you. If you're not, there's 3 subsidiary questions that you would have to ask yourself. First up, is the data subject a resident of or currently traveling in the EU? If they are, then there's additional questions you would want to ask. If there's not, GDPR is not going to apply. So the next question along this chain would be, does the processing relate to commercial activity? So an organization that's engaged in a commercial activity, if they're collecting data on a resident or somebody traveling in the EU, GDPR is going to apply. If the activity is not commercial in nature, but it pertains to some other type of monitoring of a person's behavior, GDPR is going to apply in many circumstances, and the key word there is many. I've put a note here in the slide to kind of warn the reader that this diagram is a distillation of all of the literature that's out there. It's not meant to describe all circumstances where GDPR could apply, and I've provided the citation from Article 3, that you can reference, that would give you additional information on how GDPR is applicable. Now that we've established whether or not GDPR is applicable to you as an individual or as an organization, I wanted to talk briefly about data subject rights. And there's a number of articles within GDPR that describes individual rights of data subjects. What I've done here is just pull out the key ones from my perspective. So Articles 12, 13, and 14 essentially describe the parameters of information and how an organization would determine what information about an individual is applicable under GDPR and how it would be protected and described. The remaining articles reference specific rights. So Article 15 is the let me see it right. This is the right of access. So a data subject has the right to go to a data processor, or excuse me, a data controller, and ask to see, what data the controller has on them. Articles 16 and 19 concern rectification. This is the right to have a data subject have their information corrected or provide or clarify inaccurate data. For those of you that are in the US, this is similar to an individual contacting one of the credit bureaus to provide an explanation. GDPR goes farther than that, though, and actually provides a mechanism by which individuals can request information be corrected. And it's written into the regulation, which is different than what we have here in the US. Article 17 is the right of erasure. I call this the forget me clause. Essentially, a data subject can contact the controller and request that all information on them be erased and removed from further processing. Article 18, along those same lines, a data subject can contact the controller and ask that they stop using their data. Article 20, a data subject can request that all of their data be provided in a machine readable form so that they can take that data to another controller. And Article 21 and 22, Article 21 is the right of objection. So a data subject can contact a controller and request that the controller stop calling or tracking them based upon the data that they've collected. Or Article 22, a data subject can request that they not be profiled based upon automated processing. So if an organization is making decisions on individuals based upon data that's been collected and then sending out requests or proposals or making other types of decisions, a data subject can request that cease. The next slide here, I've just provided some additional language around what I consider to be some of the key subject rights in there on portability, the right to be forgotten, and the right to access. For data portability, the data has to be provided in a commonly used and machine readable format, and data subjects always have the right to transmit that data to another controller. We've already discussed the right to be forgotten in some depth, and the right to access. Data controllers are going to be required to provide personal data free of charge in an electronic format. So those are some of the key rights of data subjects. On the next slide, I wanted to just talk real briefly about some of the significant to-dos for data controllers, and then I'll talk about some of these in a little bit more detail. First up would be the adoption of a code of conduct. Essentially, this is a formal document similar to binding corporate rules that describe the privacy practices of an organization. This is something that you would submit to your supervisory authority. Another key concept that I think deserves a lot of attention is data protection by design and default. So a little bit of background on this. Historically, organizations, when it came to designing applications or systems and collecting data, security and privacy has never really, until very recently, been a key consideration. GDPR now mandates that by law. So organizations, as they develop, implement, and execute systems and applications, data protection has to be designed into the application. It can't be something that you do as an adjunct function or after the fact. Next up would be representatives for controllers not established in the EU. So a data controller that's not headquartered in the EU, and that's not their principal location of business, we'll have to identify a representative for contact and reporting purposes for the supervisory authority. Next would be processor contracts. Processor contracts will be required for the data controller for any entities that are assisting in the processing of personal data. Also, data controllers will need to maintain a record of all processing activities. Essentially, all elements of data collection will need to be categorized and maintained and available for analysis. Along those lines, any controlling entity that is going to engage in significant or risky processing, and by this, I believe what they're referring to is sensitive types of data, so biometric, health, political, trade union, any organizations that engage in that type of processing will need to consult with the supervisory authority so that they fully understand how the data is being protected prior to engaging in that type of processing. Speaking of processing, we've got the security of processing, which really concerns three elements. You've got the pseudonymization and encryption of data. You've got the confidentiality, integrity, and availability of data, and testing and assessment processes. So encryption and pseudonymization are interesting concepts. I think most people are familiar with encryption. Pseudonymization is something that's relatively unknown, I think. Basically what it means is that organizations will have a mechanism by which they can anonymize data. So if you anonymize data, you basically take personally identifiable information and you strip out enough identifiers that somebody could not identify an individual. What pseudonymization is you maintain a separate table or database that allows you to re-enable the identification of that data. So data that's been anonymized is data that can't be reconstructed or reconstituted. Pseudonymized data can be. In terms of confidentiality, integrity, and availability, these are common concepts in the world of privacy and security. Testing and assessment, GDPR recognizes that organizations need to have robust processes in place to periodically test and assess their mechanisms to maintain security and privacy. It's cited in a couple of locations within GDPR, and organizations will have to have robust policies and procedures around that. A few more key concepts, these would be also significant to-dos, would be data breach notification for organizations that have to comply with GDPR, data protection impact assessments, data protection officers, and certification. I wanted to get into a little bit more detail on a couple of these on the following slides, so why don't we do that now? So let's talk about data controllers for a few minutes. A data protection impact assessment. So this is something that a data controller will have to do in certain instances. And those instances are anytime they're going to be doing a systematic or extensive evaluation of personal information that's affecting a large group of people, and it will be based upon automated processing or profiling. So what are some of the instances where that would occur? You've got special categories of data like racial and ethnic, political, biometric, health, so on and so forth. So you've got these special categories of data that are called out by the GDPR, where organizations prior to conducting processing on that type of data will have to do a data protection impact assessment. So I would interpret this to mean that in May of next year, when GDPR goes live, if an organization or an individual has a system or an application in place which does that, they will have had to have completed a DPIA prior to that. Subsequent to that point, any new systems or applications that come online or any changes in your business which affect those types of data, you will have to do a data protection impact assessment. And finally, the GDPR states that the supervisory authority will essentially publish guidelines on the types of processing that organizations may do that would subject them to a requirement for DPIA. So in a lot of ways, GDPR is still lacking some complete guidance on some of these requirements, but enough has been published, I think, that organizations can begin preparing for it. So some of the other elements that I've described would be certification, security of processing, and a record of processing activities. Certification is something that, while it's voluntary, it won't be a requirement. I think for most organizations, in order to demonstrate that they've actually gotten a security of processing in place, you are going to have to be certified. So GDPR requires that organizations implement appropriate organizational and technical measures to ensure an appropriate level of security relative to the risk. Well, you know, for most organizations, I think the path to doing that will be to select a security framework, whether it's NIST or ISO, something in that vein, and then have an independent entity or internal audit assess the organization against that framework and pursue certification. For formal certification, typically most organizations are going to have to go to a third party for that. But to me, that's probably the clearest path for most organizations to demonstrate certification. And then finally, the last bullet there just describes all of the information that a controller is going to have to maintain on personal data, which is rather extensive, but is an absolute requirement now within GDPR. Also, a few more of the significant requirements. Breach notification is now mandatory within 72 hours of first becoming aware of a breach. I think this is going to be one area where many organizations will find themselves in trouble with GDPR because most organizations are not ready within 72 hours to announce that they've been breached. But I believe it's something that's the right thing to do, and now it's going to be required by law for organizations to comply with that. We've already talked about data protection or privacy by design. And then the data protection officer is another concept that's relatively new. You know, there's always been, at least for the last 20 years or so, a lot of organizations with a privacy or compliance officer. But the DPO is something that the GDPR has specifically mandated, and they've come up with a list of specific requirements for it. But I wanted to do a little exercise here to demonstrate for the audience that it's not as simple as one might think. So the question before us is, do you need to hire a data protection officer? And the short answer is maybe. And the reason is that we've got different entities out there that have provided different guidance, shall we say, on what the requirements are for organizations to hire a DPO. The three organizations within the EU that are relevant here that I mentioned at the outset are the European Parliament, the European Commission, and the EU Council. And they cover essentially the legislative, administrative, and strategic decision making within the EU. And there's some agreement between the European Parliament and the European Commission. They've both stated that if you're a public authority or if you're an entity with processing operations which require regular and systematic monitoring of data subjects, that you need a data protection officer. Where they begin to vary a little bit is that the European Parliament in its guidance has said that entities that process data for more than 5,000 people in a 12-month period or process special categories of data like health or religious or political information, they need a data protection officer. The European Commission has simply stated that organizations with more than 250 employees have to have a data protection officer. So I think for organizations that only meet one of those, you'll have a decision to make about which course of action you want to follow. The Council of the EU, which is essentially a strategic body, they've got voting members from essentially the head of state for the 28 members of the EU. They haven't published any guidance on agreement with the Parliament or the Commission, and essentially they've just said that a DPO is not mandated unless it is required by EU or member state law. So, you know, once again, the Council has something a little bit different than the Commission and the Parliament, but overall, I think most large organizations that process data, you know, for, shall we say, thousands of people, or that have special data within their purview are probably going to need a DPO. So what are some of the DPO requirements? The DPO has to be a professional, and they have to be hired or appointed based upon a specific set of professional qualities and expert knowledge. The GDPR has not really gone beyond that in terms of saying they need a specific certification. There are certifications out there that I think demonstrate that first bullet point. The DPO can be a staff member, so it can be an employee of the organization, or it could be outsourced. But the organization, the data controller, does need to provide all of the relevant contact information to the data protection authority or the supervisory authority. One of the other things that's, I think, key to the description of the DPO is that they have to report to the highest level of management, and they can't have conflicting job duties. The DPO can have other responsibilities in the organization, but it's important that they don't have anything in their job description which would conflict with them and their ability to establish guidelines and expectations with regard to privacy for the organization. So in the short time that we have left, I wanted to just quickly summarize what we've talked about today and then invite questions from the audience. So in summary, I think these 9 bullet points are really where organizations can get started with GDPR if they haven't already. I've been asked many times, you know, over the past year or so from different clients, you know, what do we need to do first? And what I've tried to do here is memorialize that in one slide. So I think to start with, organizations need to understand GDPR, and they need to take GDPR concepts and implement them or incorporate them into their security awareness programs. So for organizations that do newsletters or periodic training or orientation, they need to talk about GDPR concepts, you know, during that process and make people aware of it so that it's built in. This is helping to comply with that privacy by design component to GDPR. Probably one of the biggest areas or most resource intensive activities is identifying and documenting the personal data infrastructure. Essentially, organizations have to understand where they're collecting, where they're storing, where they're transmitting and or how they're transmitting and all of the elements around the processing, i.e., what it's being used for. Organizations definitely need to update their privacy policies and pay special attention to access requests. Organizations need to have a highly formalized consent management system to include parental considerations. Under GDPR, children under the age of 16 have special provisions that attach to them and their data and how you acquire consent. Organizations need to deploy an incident response program for data breach if they haven't already. This is very critical because now there's going to be a requirement to report on this within 72 hours. And organizations that fail to do this, I think, are just inviting a whole list of problems in addition to the huge monetary penalties that may now attach. We've talked extensively about data protection by design principles, as well as doing the data protection impact assessments, and appointing a DPO for those organizations that need it is obviously a good first step. And then finally, the organization will need to identify a lead data protection authority or supervisory authority for cross-border processing if it's needed. So if you're an organization that's doing business in more than one member state in the EU, you will need to identify a lead supervisory authority. That would essentially be a supervisory authority within one member state that you will report to for the purposes of GDPR compliance. So in summary, I would like to thank everybody for their time today. I would also like to remind everyone on the webinar today that here at Secure State, we're a strategic advisory firm, and we have a number of analysts and consultants here at Secure State that are well-versed in doing things like security awareness training and process and data flow mapping. We excel at assisting organizations in developing a roadmap for strategic decision-making as well as tactical implementation. We do a lot of policy development for clients. And then on the technical side, we've got a number of analysts here who are well-versed in doing technical evaluations of controls, as well as helping to develop incident response and risk assessment programs. Also, we have an internally developed tool for doing data protection impact assessments that we think is going to be very valuable here in the near term as we get closer to that GDPR implementation date. So I'd like to thank everybody for their time and attention today. I'm more than happy now to take questions. Okay. So it appears that we have okay. So the first question here deals with erasure and data portability. And the question states, does it take into account AML and other regulatory record retention requirements? I have to apologize, I'm not familiar with the AML acronym. But I think for erasure and data portability, the comment that I would have there is that GDPR does not go into a lot of explicit detail. Essentially, it describes what I would call principles. It has guidelines, on thou shalt, but it doesn't go into a lot of detail. I think ultimately those will be governed by the supervisory authorities and the commission. But what I'd like to do on this question is research AML a little bit more, and then we can respond back when we publish the blog, which should be coming out here in the near future. The next question is, can you discuss a little bit about what does and does not apply to organizations that are strictly data processors? Well, I think first and foremost, GDPR was built for the data controllers. I mean, the onus is on the data controller because they have the relationship and they determine, um, how the relationship is being managed and what is being done. Certainly, data processors are obliged to comply with GDPR, but they do not report directly to the supervisory authority. They report to the data controller, and the data controller reports to the supervisory authority. So data controllers, their relationship is governed by contract with the data controller. So in that instance, it's going to call out in your contract what you have to do for that data controller. Beyond that, the supervisory authority will probably have more detailed guidelines on what data controllers and processors have to do. So the next question is another data processor question. So I think we've already answered that one. But in our blog, we'll get into a little bit more detail on the differences between controllers and processors. And the next question here is, this is an interesting question. We are a retail store in the U.S. Going to be affected by this. I've gotten this question from different clients. I think the answer is it depends. Certainly, if you have an e-commerce presence where you have individuals in the EU that are visiting your site and you're collecting data on them, I think GDPR could apply to you. In your second part of your question here about the frequent shopper card, I think once again, it depends on the number of individuals that you've signed up for this and the size of your organization. In your third part of your question here, you ask about stores, which I'm assuming stores here in the U.S. if a foreign customer comes in. So somebody from the EU is on vacation in the U.S. and they walk into your store. Once again, I think there's really no difference here where the EU resident is. GDPR applies to them regardless of where they're at. There hasn't been any court decisions on this, but once again, I think for low numbers of customers, I would say probably not. For higher levels, like above 5,000, I would say definitely. This is one of those gray areas that GDPR has not really come out with a whole lot of guidance yet because it hasn't gone into effect and there hasn't been any court decisions to provide, sort of detail around the edges. And then the next part of your question is, do they have to get consent if they're just buying and paying with a credit card? I would say no if they're just buying items in your store with a credit card and you're not collecting any personal information on them. Certainly, PCI DSS applies, if you're collecting credit card information from them. And then finally, online orders. Once again, this is the e-commerce question. I think if you've got an e-commerce presence and you're collecting data on EU residents, once you get above that 5,000 individual threshold, I would imagine GDPR applies. Yes, we will be sharing the slides with those of you that were on the call today. The next question, will hosting be physically required in the EU, and do you think US versus Microsoft may impact the form of enforcement on that point? hosting physically will not be required in the EU. This is where cross-border data transfers come into play. So an organization that's doing business in the EU, whether you're headquartered there or not, certainly if you've got the data center located in the EU, you're not going to have quite as many requirements. If you've got the data center outside of the EU, so that data is now crossing that transnational border, you've got additional requirements that you'll have to meet. I'm not sure. I think in the US versus Microsoft, I think you're referring to a specific legal decision. I would have to look that up and then answer that one in the blog. The next question here is, I work for a Canadian-based airline and draft a lot of contracts with suppliers who say they should only be governed by privacy laws in their own country. What is the best way to get these service providers to understand that there must be consideration given to GDPR? Well, what I can tell you is, in my experience, I went through this a lot in the healthcare space for many years. In that here in the U.S., entities that deal with healthcare information were initially the only ones required to comply with those rules. Later on, the legislation was updated to include processors and subsidiaries, or business associates, in this case, data processors. Now everybody's on the hook. And to me, this just comes down to education. Certainly, I think pointing out the financial penalties to a potential business partner and explaining that 4% of your revenue is on the line by doing business that's applicable to GDPR. I think in terms of getting their agreement with them, getting their agreement, it has to be in the contract that they will comply with GDPR. I would never recommend to a client, in an agreement that clause be excluded. So I think that's probably the best way to handle it. What impact will Brexit have on UK companies and GDPR? This is a very good question. There's been a lot of information written about this. It does appear that organizations that are based in the UK and will still have to comply with GDPR. I would assume, and there's a big assumption here, is that if Brexit goes through, that will have to be separately negotiated. In other words, once the UK leaves the EU, you're now going to talk about a cross-border data transfer between the UK and other countries in the EU. So just like everything else that has to be renegotiated under Brexit, GDPR is going to fall into that category. So it's going to mean for UK-based countries doing business in the EU, they will have additional requirements to meet in order to do business in the EU. Do U.S. hospitals that do not reside in the EU but may serve EU citizens need to comply? Yes. I think that once again, it's going to depend on the number. It's going to depend on the type of information that you're collecting. Certainly, I think for data that's anonymized, there might be safe harbor. So in other words, if you're a healthcare institution in the US and you're doing research and you obtain data on EU individuals that's been anonymized, I think there might be some safe harbor provisions in there. But certainly if you are the data controller, meaning you're a healthcare entity that's providing healthcare services over the web, answering questions, doing, whatever you may be doing that's rendering care to EU citizens, you're going to have to comply with GDPR. is there a cost-effective way to pseudo-nominize non-uniform content such as individual names? In terms of pseudonymization, we're still researching how organizations can best employ that. My biggest concern is that when you're stripping the data out and you're going to maintain separate records or key files, these are going to be key targets for hackers because it's basically the keys to reconstituting the data. I think this is an area where the service providers that do this kind of thing are not widely known. We're certainly going to comment on this in our upcoming blog, so hopefully we can provide you with some greater detail there that helps to answer that question. Okay, so let's see here. Okay, someone's just informed me AML is the Anti-Money Laundering Bank Secrecy Act, so that's very helpful. We are a manufacturing company that has global customers. Our sales force, of course, will make contacts with EU companies and have information from their counterparts. How is business card information handled? If someone hands their business card, one would assume consent. The way GDPR is written, that would not qualify as consent. According to my reading, handing somebody a business card is not consent. Consent has to be recognizable, and there's no evidence that consent has been given. To me, the salesperson who's making a visit to a commercial enterprise and they're asking for information, that's a tricky question. I think it's something obviously that's very commonplace, but we'll probably have to think about that one in a little bit greater detail and do some more research to provide you a definitive answer in that regard. Do you have any information on how higher ed institutions should handle meeting federal regulations and meeting the GDPR regulations with EU students? There's not been any specific guidance that I've seen in terms of meeting those regulations. Certainly, within GDPR, there are allowances for when a party outside the EU has to comply with their own state rules and regulations. So when the safe harbor was invalidated, the US and the EU got together and they developed a new framework called the US-EU Privacy Shield. There might be some language in there that I think might govern educational transfers of data, so we'll be sure to include that in our upcoming blog. Does the number of customers residing in the EU less than 1,000 impact need for GDPR compliance? We already have GLBA, which is Gramm-Leach-Bliley Act compliance requirements. So if I read the question correctly, you're saying that you have less than 1,000 customers in the EU. I'm going to assume, since you referenced GLBA here, that it's financial in nature. This is one of those that I think will depend on the size of your organization. As it stands right now, it may not, but obviously there's more guidance to come from the Commission, I believe, in terms of how to drill down for those types of scenarios. GDPR makes specific allowances for small companies. So depending upon the size of your company, you may have a provision in there that would allow you to not have to comply with GDPR. What we will do is hopefully provide a little bit more information in our blog that can answer that in more depth for you. We deal with refugees in the EU. How does GDPR apply? I think, if you're a public entity in the EU, you do have to comply with GDPR for non-EU citizens that are currently in transit within the EU. I'm not that familiar with international law on refugees, but it certainly is an interesting question. We will look into that and see what additional information we can provide. At this point, we've actually gone 2 minutes over the presentation. I would like to thank everybody for their time and attendance. We will strive to answer the remaining questions that we didn't get to in our blog, which should be published shortly. Thank you very much and enjoy the rest of your day.